Hello, this is John Mullen. The courses are ie411 and ie561, and this is lecture number 4. In this lecture, we're going to talk about two government programs. One is workers' compensation, and the other is the famous OSHA, which probably everyone's heard of. So let's get started. People have often tried to improve workplace safety through government action, and we're going to describe two such attempts in this lecture. One is workers' compensation, and the other one's Occupational Safety and Health Administration, otherwise known as OSHA. We'll talk about workers' comp first, where it came from, the history, what are the plans like, and differences among the different laws. And then we'll go to OSHA. We'll talk about the, is that right? Silmar? I'm not sure that's spelled right. Tunnel disaster. How well is OSHA working? And we'll also talk about state programs, such as in New Mexico. Motivations, we talked about before. The motivations in these programs is, again, to get away from revenge. Restoration, this would be workers' comp. Workers' compensation focuses mainly on restoration, and OSHA mainly on restraint. Okay. Workers' compensation. At the start of the 20th century, working conditions had improved, but they relied on workers suing whenever they got injured. So, you know, unless someone's willing to go through all the trouble of lawsuit, nothing would happen. Workers' compensation, the idea was to reduce the need for lawsuits, but it was very difficult to implement. And as a result, each state has its own law, and the laws are different as you go from state to state to state. Okay, so what we're going to talk about, how they work, what are the benefits, what are the costs. In historical setting, we're going to talk about constitutional issues, the Triangle Shirtwaist Fire. Anyone know about that? Well, this is almost like a history class, right? And differences among the workers' comp laws. So, actually, I got this order wrong. So, we're going to start with the historical context. In 1900, in the U.S., common law required a safe workplace and tools, making workers aware of dangers, competent co-workers, and competent supervisors. That was really radical, right? And rules to protect safety. But there's a big but. If an employer failed to live up to the law, the employee had to sue. It was a tort, not a crime. So all the laws were there. Everything was in place. The lawyers were supposed to do this, this, and this, and this. But there wasn't anything really to compel them. Okay. So from the employer's view, the common law increased liability. Contributing negligence had been thrown out. Fellow employee had been thrown out. Assumption of risk had been thrown out. All these things they had used before as defenses. But they still had some things on their side. Long court battles were expensive. On the other hand, if they did something really nasty, and it came out in court and in the newspapers, the company could lose public support. If someone really persisted with them with a lawsuit, there could be a large award. Of course, this may be 20, 30 years down the line. And the bad feelings associated with this kind of contention disrupted the workplace. So the employees, even though they had a lot of advantages, they weren't happy. From the employee view, The common law protected requirements for safety. It protected the employer's liability, but the employer could escape liability because workers had little money to spend for lawyers, long court battles, etc. So as a result, workplaces were still more hazardous than people would like them to be. Any comments or questions? Okay, so what is workers' comp? Yeah, there we go. When a worker is injured, workers' comp provides quick medical care, replaces lost income, facilitates rehabilitation, and encourages an open investigation because they're more asking the question, what happened here, rather than whose fault is it? Okay. Workers' comp laws also encourage safe practice and conditions because a lot of these laws are essentially a kind of insurance, and if you want to get the better rates, you have a safer workplace. It encourages rapid settlement of claims. That's claims, not clams. Oh boy. It looked good on the draft. Less disruption and better workers' morale because these things were settled quickly and didn't drag on and on. After a while, we added some things: compensation for permanent injury, safer workplaces. The states or the insurance companies would come out with guidelines to improve safety and lower rates, and better safety records. Regardless of what you did, if you have a better safety record, the rates went down too. And the workers' comp laws also reduced liability because this compensation was provided as a replacement for the liability and lawsuits. Early workers' comp laws. Prussia had the first workers' comp law in 1838. By 1852, every country in Europe had workers' comp laws. Now we come to the United States. 1908, what's that, 50 years later, the feds put in a workers' comp for federal employees engaged in hazardous civil service. In 1909, Montana passed a law to cover minors. In 1910, that law was declared unconstitutional. In 1910, New York passed a law to cover hazardous occupations, and in 1911, that law was declared unconstitutional. So we had a little trouble at the beginning. Here's the problem. The Fourth Amendment limits on search and seizure. Manufacturing facilities were private property. And also, from the employer's viewpoint, workers' comp, because it didn't exclude liability at that time, essentially left them open to double jeopardy. They'd have to pay once at the time, and then maybe pay again later. The 14th Amendment, the citizens' rights were not to be abridged, and this was interpreted as workers had the right to work under dangerous conditions. You don't want to be depriving people of their rights. Triangle shirtwaist. Nobody heard of it, so I'll talk to you about it. This happened in 1911, and this event changed a lot of things, including workers' compensation. This is the building in question after the fire, which occurred in that building. Triangle Shirtwaist was a clothing factory. Shirtwaist was a kind of dress. It was 10 stories high. The stairs were narrow, but they were in code, within the code. They had 20-inch exits, 20-inch. Others were locked to avoid pilferage. There were 600 workers, mostly young women, in the factory. Some workers were subcontractors, didn't work directly for the shirtwaist company. There had been no fire drills, in spite of the fact that these were required in the existing code. March 25th, 1911, on the 8th floor, there was a fire that broke out. And, of course, everyone wanted to get out. The stairways and the exits became clogged pretty quickly. Some workers were required to clock out before they could leave. Right. As a result, some of them ended up jumping to their death because they couldn't get out. 146 were killed and 70 were injured seriously. That includes burns. Here's a little view of the situation. This is where the fire occurred, and you can see in here just how tightly packed this is with workers, and you can see also that the exits to get out are very limited. So basically the fire trapped these people on the upper floor, and mostly it was among these people that the deaths occurred. The lower floors, people were able to get out. The building was mostly up to code, but the 9th floor doors opened inward, which at that time was a no-no. There had been no fire drills, which also was a violation of the code. On the other hand, the owner was found blameless, and this I find amazing. The owner claimed that he was unaware that the doors were locked. Okay. He probably played golf with the judge, I don't know. It did lead to a change in the New York fire codes, and New York workers' comp law. The previous year, the work comp law was declared unconstitutional. That year, it was passed again, essentially the same law, and wonder of wonders, it was now constitutional. Did I mention most of the victims were young women? It's amazing what can happen. Okay. Any questions or comments? Okay, so the first war laws in New York, 1912, triangle shirtwaist. In 1910s, there had been 9 states that passed non-compulsory laws. Hey, you want it, you can have it. And again, the carrot and stick here was the fact that it would reduce the employer's liability if they took the workers' comp. 7 states amended their constitutions, another way to deal with something that's not constitutional. There were some compulsory laws in the 1910s. And then finally, in 1917, the U.S. Supreme Court ruled that the compulsory laws were in fact valid. So they took about 7 years and 1 fire. But here's where we are. Every state has its own, plus the District of Columbia, plus Guam, plus Puerto Rico, and the Virgin Islands. There was never a federal law that covered all the people in the states. There are federal ones, one for federal employees, one for longshoremen and harbor workers, and one for the District of Columbia. Those are federal, but they don't cover the country as a whole. Most laws cover 90% of employees, but every law is different. Coverage, about 90% of employees. State workers normally work under the law. The benefits, okay. Medical care, rehabilitation expenses are covered almost universally in these laws. Lost wages are replaced, but almost every state has a cap. So if you're in a fairly high-paying job, you don't get nearly as much in replacement as your wages. Burial costs, if worse comes to worse. If you're impaired, if you lose the loss of an arm or a leg or something like that, there's also compensation for that. And if it's mandatory, then coverage is assured. If the employer does something wrong, the employee gets in trouble, but the worker still gets taken care of, if it's mandatory. Typical coverage, the employee's covered if they're in the workplace regardless, if they're traveling on company business, even if it's out of state. Typical coverage, even if outside working hours on the premise or out of state, even if the employee is at fault within limits, even if the injury is not work-related within limits. So here we go. Typical requirements. Injury due to accident. It cannot be horseplay. It's amazing how often this word comes up. Basically, this is an unsafe activity that your employer has told you not to do. Okay? Why it's called horseplay, I have no idea. If you get drunk and get injured, in most cases, you're not covered. Okay? It has to come out of employer. So if you're traveling because your employer sent you somewhere, that's out of employment. During the course of employment, for example, if you're in the plant and you're working on your son's bicycle and you injure yourself, you probably won't be covered. On the other hand, if you're in the plant and you're having lunch and some kind of green fumes come out of one of the departments and overwhelm you, you are covered even though you're not working strictly at that time for the employer. It's, as you can see, this is kind of an interesting patchwork. Some states have statutes of limitations, but not all. Now, remember we talked about the motivation? Let's see what can happen when things go wrong. George Matetsky was injured. He could no longer work. He waited, unfortunately, over a year, and his claim was disallowed because of the statute of limitations. He tried 3 more times to get it covered. It was disallowed every time. So, as a recourse, he made 37 bombs. Yes, there were a few serious injuries, and he ended up in a mental hospital for 17 years. So, I'm not so sure statute of limitations are a good idea. And it gets weird, like Johnson versus Smith, New York State. He got typhoid fever from a restaurant while on a business trip. The courts held the employer was not responsible because it wasn't during business hours, and the restaurant was not run by the employer. Well, that seems pretty clear. But now we have Wiseman versus, Los Angeles, California. Went on an overnight business trip. He met a girl in the bar and went to the room. Later, due to a cigarette, a fire started and both were killed. The wife sued and got compensation. So, if you can make sense out of this stuff, you're smarter than I am. I guess that's why we need lawyers. But remember, every state's law is different. So what flies in one state doesn't apply in another. Final note, if an employee of a California company were to travel to New York, the California ruling would apply. It's the state of the usual or parent employment that counts, not the state in which the event occurs. Now, this brings up some things. Let's say you work in locations in several states. One of those locations will be designated your primary for workers' comp purposes. Let's say you're transferred to the state. You may remain under the original workers' comp, or in some states you may have to actually resign and get rehired in order to be covered under the new state. I didn't write these laws. Some workers may be exempt. For example, railroad workers who are always traveling around, maritime workers and federal workers, they may be permitted to retain their original state or may be permitted to transfer their state depending on what's going on. Agricultural workers, 14 states cover the agricultural workers in ways similar to most workers. 26 limit the coverage to agricultural workers. Remember, we saw at the beginning agricultural workers have an unusually high accident rate. I'm not sure if this is the cause or the effect. 13 require no coverage at all. Domestic workers, there's limits on hours. Casual workers, limits on hours and duration. And nonprofits, 10 states require coverage, the rest don't. Small company exclusion, there isn't one in New Mexico, but some states exclude companies with so many employees or less. Independent contractors, It depends on what degree they are working for the company and the laws. Minors is kind of interesting. In some states, there's higher penalties for minors being involved in dangerous activities. In other states, if a minor engages in a dangerous activity, the minor is not covered, even if the employer paid workers' comp for the minor in the other jobs. If the employer puts the minor in a dangerous job, the minor is not covered, which also means the minor can sue. And extraterritoriality, you can be in another state, or you can be outside the U.S. and still be covered. Questions? Okay. Workers' comp rates. These are explained in the text. Basically, the insurance rates are based on the workers', what was that? National something codes. I was going to write that down. They used to be called Standard Industrial Classification Codes, SIC, but someone decided that was too easy to remember, so they changed it. There's a website where you can go to and see what these codes are. And what happens is, depending on what code your employee is coded under, that the workers' comp rate changes. And if an employee works under more than one code, then what they do is they prorate the fraction of time the employee's under one code and under another. Okay? So that's very important. The second thing is your total payroll. Once you figure out the basic ratios, then you multiply that by your total payroll to get your rate. You can have an adjustment to the rate depending on what the conditions are in your plant, especially with private insurance. And also a lot of insurances take into account your experience, what your safety record has been over the last 3 years. And it could be administered by the state or by private insurance. And some large companies self-insure. They just say, okay, we're going to set aside a few $1 million to cover this, and we agree to do this and do that, and they don't have to pay for external service. Okay, so now, just in our area here, is it mandatory? Yes, in New Mexico. No, in Texas. Yes, in Arizona. Can you self-insure? Yes, in all 3 states. Is it state-funded? Yes, in New Mexico. No, in Texas. Yes, in Arizona. Can you have private carriers? Yes, in all 3 states. Can you have waivers? The company can say, well, under these circumstances, we don't feel we should be covered. Yes, in New Mexico and Arizona, but no in Texas. And if I picked 3 other states, I'd get 3 other mixes. Problems. One is medical diagnosis. The employer employs the doctor. The doctor may decide that what you have there is just an ordinary rash, which you probably got from poison ivy, not from that green slime that oozed out of the printing department, okay? You could have incomplete coverage. In many states, ag workers are not covered, and underage minors may not be covered. Inadequate. Some of the caps on reimbursement are actually under the poverty level. These caps typically were set like 40 years ago and haven't been indexed to inflation. This usually ends up being a very low compensation for most workers, but then from the industrial standpoint, they want to get the people to come back to work. So there's always that trade-off. And sometimes the rates are not kept up or indexed, so you might have a case where a state hasn't changed rates for 10 years, and then they suddenly change them, and everything changes. And this affects a company. And some employers just write off the premiums and don't seem to appreciate just how much money they can save by looking at the experience factor and the conditions. They just write it off. There was one local company, they were paying $2.5 million a year, and one of our student teams went down there, and they suggested changes that reduced it to $200,000 a year. It took a few years, but they were just ignoring the fact that they could reduce this cost. Okay, as a summary, worker comp plans are a kind of insurance for on-the-job injury. We need them because lawsuits are time-consuming and costly. Generally, they cover anything on the workplace or anything work-related. Benefits, what are benefits? Medical bills are covered, some wage replacement, okay? The costs are like an insurance premium, whether by the state or by private, and they're based on the nature of the job, the amount the person is paid, in most cases, the conditions in the working facility, and the historical record of safety for that company. What's different about the work comp laws? Every state has one, and the federal government has 3. Okay? And one of the problems we have is that it varies by state to state. This can be a problem for a company that's in more than one state. They have to, when they're trying to come up with a corporate policy, they have to take into account that things are different in New Mexico than they are in Texas. Okay? So that's what we got there. And one final thing, in some states, the workers' comp programs are underfunded, which can be a problem because if they go under, then the federal government has to take over. And that's another thing, which is weird because the federal government doesn't write the law, but they have to take over the fund. Any questions or comments?
NAICS stands for North American Industry Classification.
You looked it up? North American
Industry Classification.
North American, really? North American Industry Classification Codes.
Yep.
Yeah. That's interesting. Okay. Probably had something to do with NAFTA then. North American.
They pronounce it NAICS.
Okay. Any other questions and comments? Okay, good. Now let's look at OSHA, the other guy. Now OSHA, workers' comp is aimed at restitution and restoration. OSHA is aimed more at prevention. So it's the Williams-Steiger Occupational Safety and Health Act, in case this comes up in a trivia quiz. This established the framework. Employers and employees are encouraged to prevent accidents. And the act has been modified over time, but the primary goal remains the same. There's been many evolutions in OSHA. So we're going to look at what is OSHA, why do we have it? Yeah, Sylmar Tunnel disaster. What's it made up? How's it made up? How well is it working? And we're going to look at state programs, for example, New Mexico. Here's the website, www.osha.gov. You can go there and find, well, we're going to see that in a minute. OSHA's mission is to assure safety and health of America's workers. Their activity, they set and enforce standards. They have an extensive training, outreach, and education program. They establish partnerships with industries to improve safety. They encourage continual improvement in workplace safety and health. They're never quite satisfied with what they are. They started in 1970. It's what, 42 years ago? Wow. Public Law 91-596, approved December 29th, 1970. There were major amendments in 1990, amended again in 1998. There have been many minor amendments. And this whole thing is maintained by the U.S. Department of Labor. Here's some recent stuff. In 1990, they updated the penalties and caps because they decided they just weren't big enough to get industry's attention. In 1992, they started the Workers' Family Protection Program. Very often what a worker does in the workplace impacts their family. So, and of course, the worker's family impacts the worker's attitude in the workplace. So they started bringing that together. They had a training program for lead-based paint, which is still a problem. In 1995, they started giving reports to Congress. In 1998, they brought in the U.S. Postal Service. They had compliance assistance programs. You know, this website, when you go there, you're going to see it's huge. We used to get manuals, and they're like phone books. And they're just full of all this, do this, do that, don't do that, do this. And it's written in that kind of language that manuals are usually written in. And everyone's trying to figure out what's going out. Now it's all on the web. There's a lot more interaction. It's much better than it was, but it's still huge. So a company may have trouble trying to decide how to comply. Well, you can ask OSHA. If you're asking them for assistance, they can't use enforcement results. In other words, the people who do this have a firewall between them and the enforcement branch. Furthermore, in 1998, they said, you cannot evaluate OSHA employees on the basis of how many enforcements they've had, because there was a feeling that people were just doing a lot of stuff just to get advanced. In 2002, the bioterrorist threat research was put in, and in 2004, the federal government itself became subject to OSHA. What's that? 70, 30, only 34 years. Okay. OSHA's aims, you want to help employers and employees make the workplace safer. They look at this as a partnership. One of the things they do is that as things happen in industry, they capture that information and put it into a database, which they then publish reports on. They also foster research in safety improvement. They set medical and safety standards, so people are all kind of on that same level. They take that knowledge they have in here and they massage it and they codify, they put it together, and then they disseminate that back to industry through reports and through the website. And for those guys that just can't learn the usual way, they also have enforcement. Initially, this was a big part of OSHA, enforcement. Now it's become a rather small part, because for the most part, employers don't want to harm their employees, regardless of what you might see in the movies. So, Silmar Tunnel disaster. This is 1971. It was a small explosion in the tunnel on June 22nd. 4 men were injured. Tunneling was halted for 12 hours. The next day, they improved the ventilation, work resumed. The gas level was such that they had 30 to 40 stoppages that day. And here's the weird part. It was okay for the workers to smoke with flammable gas coming in. I don't know whose idea that was. Then on the next day, there was an explosion that killed 17 people, 16 Lockheed employees, 1 Los Angeles Metro Water Department employee. 9 were killed by the explosion and 8 suffocated in the smoke and dust as an aftermath. So they had a trial. Lockheed and 3 employees. It was the first prosecution under a law that was passed in 1913. Think about that. 60 state safety codes violations. Lockheed was found guilty of 16 counts of gross negligence, 9 safety code violations, and the maximum fine was $106,250. This is Lockheed we're talking about. Okay, they probably spend more than that on trash cans, right? Now we continue. The project manager, 16 counts of gross negligence, 9 counts safety violations, was sentenced to 20 years, 6 months in jail. But he appealed. An appeal that was reduced to 5 years plus 10 years probation, but he got a new trial, and then it was reduced to $6,875 plus 3 years probation. Okay? More. The work crew supervisor was not guilty. Okay? The safety engineer, on the other hand, was guilty. What's this course about? Okay, just 3 safety code violations, 18 months in jail that was later reduced to 3 months plus 10 years probation, but he got another trial, $625 plus 1 year probation. So, as you can see here, even though technically there were teeth in this law, it was very, very hard to get the law to bite anybody, at least to the extent that it would change their behavior. Although after going through all these trials, I'm sure the individuals did change their behavior. Actions, well, civil actions. Lockheed employee versus the Metropolitan Water District. They couldn't sue Lockheed, but they did get a $9 million settlement. Well, that probably turned heads. Then the Metropolitan Water Department versus Lockheed. I've tracked this down repeatedly over about 15 years, and I still don't know what happened in that case. So I presume they either had a settlement with an agreement not to talk about it, or it's still pending. So, as an aftermath, you had civil actions. Lockheed, Metropolitan Water District settled for $9 million. No results as of 2012 on the other. But this was the first time that a corporation in the United States was held liable for gross negligence. First time ever. It was the first prosecution under the 1913 Safety Code, and it was the first time that individuals were held criminally liable without proven guilt or intent. They became accidental criminals. Okay? So what happened? Well, one thing people realized, this law is not so good, okay? It only had misdemeanor penalties. So in 1973, they passed a new law with more severe penalties and the possibility of charging someone with manslaughter. But it didn't clean everything up. There was a poor connection between research and practice. There was a lack of uniform collection of data, a lack of dissemination. Rules were made by people that didn't have a technical background. Rules were interpreted by people who didn't have a technical background. And even if things were interpreted, there was no appreciation of their importance. And this caused problems in the trials because you had opinions coming from everywhere, and the courts really weren't equipped to decide who really knows what they're talking about and who doesn't. We still have a problem, too, with the question of jurisdiction. Workers' comp from another state. There was an uneven level of authority, and it was really unclear who had the authority to help the operation. And this came up as a problem in the trial because if a person didn't have authority to halt the operation, you can't hold them responsible for not halting the operation. And so there was that. And the system was reacted. It depended on the threat of a lawsuit. And as we saw, even the possibility of jail was very remote. Now, this was the situation prior to OSHA. And this made a lot of people unhappy because they said, look, what we're doing right now isn't making things safer. We need something better, something that will address these kinds of issues. Okay, any questions or comments? All righty. So what's in OSHA? Well, first of all, there's a set of federal minimum standards. And these are things like, for example, if you're going to have an office in an office building, it has to be able to withstand smoke and fire for 1 hour. If you're going to have a stairway in a certain application, it can only be so steep, and it must be so wide, and it must have certain handrails. Everything is specified. Federal or state administration, the program is federal, but a state can administer the program, providing the state program is at least as good as the federal program. Department of Labor and OSHA are involved with compliance, and then the OSHA RC Review Court, they review any fines or penalties against companies to see if they should be adjusted, and usually they are to some extent. Then Health and Human Services, NIOSH, they do research and education. They collect all that data and look at it and try to make sense of it, and then they not only disseminate the information, but they try to put it in a form that can be used to educate people and train them. That's all OSHA, all those different parts. Let's look at the standards. This is technically 29 CFR. There is a link on the course page to this. Part 7 is information control. Part 19, procedures. Part 22 is the Review Commission. 24 is the Privacy Act. And, of course, all those numbers in between are there. This is what the website looks like. And really hard to read. They used to use bigger letters, but now they've crammed more and more stuff on there. But let me just show you what we got. Up here we get an A to Z index. You can go to Spanish if you want to. You can contact them. There's frequently asked questions. You can read about OSHA. There's a search box up here. So if you're looking for something like fire hoses, you can type it in. It'll show you everything that has to do with fire hoses on this site. Here we're at the home. This is for workers. This is regulations. This is the enforcement records. Here you can get data and statistics, training, publications. They have news, and they have a section for small business. Okay? And plus all the busy stuff that's on there. It's huge. Okay. Primary information are regulations, enforcement history, data and statistics, publications, news, and then a segment on training. Now here's, if you click on regulations, you get something that looks like this. And there's a little blurb up here, and then there's quick links over here, and public resources, and down here is an index to all the individual regulations. And that's what you do is you go to this website and you click on the regulations tab. And now this is part 1910 subpart E. Okay? 1910 subpart E, means of egress, how to get out of something. So we have here exit routes, emergency action plans, fire prevention plans. There's a table of contents, coverage and definitions, compliance with alternate exit route codes, design and construction requirements for exit routes, maintenance, safeguards, and operational features for exit routes, emergency action plans, fire prevention plans. Each one of those is a link, which will open up to another page, which has a bunch of links on it. Any questions? All right. Compliance. Now, this is a rather interesting scheme. Inspections can be triggered by a death or multiple serious injury in a facility, somebody giving a credible report of hazard, random. If you're in a hazardous industry, they just basically flip a coin, and if it comes up whatever, then you get inspected. There's also routine for reporting on Form 300, and you can actually invite OSHA visits. And you might say, well, why would you do that? Well, the answer is they can't assign penalties if you invite them in, although they did try a few years back, and that didn't turn out well for OSHA. Here is a diagram which I put together, and I ran it by a fellow in OSHA, and he says, yeah, that's it. So they claim it's it, so let's go through it. We can have a complaint. Now, is it valid or not? What's a valid complaint? Well, if you work in a factory and you file a complaint, that's valid. If your wife hears you talking about it and she files a complaint, it's not. Okay? If you don't like the company and you want to file a complaint, that's not a valid complaint. A valid complaint has to come from somebody who has immediate knowledge of the situation. Now, the employee could be disgruntled. Okay, that's always possible. But as long as a person, as we reasonably expect that that person knows, has seen directly what's going on, it's valid. Okay. So now the question is, does the employee sign? In a surprising number of cases, the answer is no. But if the employee does sign, it's a formal complaint which triggers an on-site inspection. OSHA goes out and says, what's going on out here? Now, if the employee doesn't sign, it's an informal complaint, and some manager looks at it and says, well, this isn't terribly serious, so I'm going to send a letter to the company saying, we have a report that you're doing A, B, and C. What's going on here? Okay. On the other hand, if the manager thinks it's serious enough, he's going to say, oh, what the heck, let's go look. Now, a referral is something a little different. For example, you might get a referral from the Form 300. Okay? Now, this would be from someone who doesn't have direct connection, but does have reason to know what's going on. So if it's valid, then it comes down to the manager. The manager, once again, could say, well, let's go look, or the manager could write a letter. So let's say that a letter has been written. The employer sends a letter back and says, yes, this was a problem, but we fixed it. We did da, 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 and da. And the manager looks at the letter and says, okay, this looks like this matter is settled, and then closes the file. On the other hand, if a guy gets the letter back, which says basically, who the heck do you think you are asking me about this? Or the guy feels he's evasive, or he's not completely confident the guy is doing what he says he's doing, then they visit. Okay? And then finally, program. If you're in certain high-risk industries, they have a program that randomly selects individual companies on a random basis. And when your number comes up, then you get a visit, even if no one has said anything about the place being unsafe. Any question on this very sophisticated chart? It took 3 tries to get this right, by the way. And then the guy asked for a copy because apparently they didn't have one. Okay, so we have NIOSH and OSHA. OSHA is involved with education and enforcement, education to industry, enforcement industry. Industry provides data to NIOSH through the Form 300s, which we'll talk about. And then NIOSH compiles that information and feeds that back to OSHA, which, among other things, says these are the most hazardous industries or occupations. Any question on that? Okay. Form 300. Now, in the text, I believe this is called Form 200. Since the text was printed, they add 100 to the form name. This is actually a poster that people write on and put up in the workplace. It has summaries of every work loss, accident, or illness, and there's very precise definitions about what comprises that. Annually, the company has to file a report with OSHA, which includes what's on this 300, plus further details in reports that accompany the form. And what is this for? Well, one thing, this poster has to be posted where employees can see it. So this makes employees aware of what's going on in the workplace. Now, lately there's been some changes to that. The employer can post their Form 300 on a website, which the employees then can go to and see. They're getting away from just putting it on the wall, because it creates a problem in a large company finding a place where all the employees will go by. But it's still posted. That way the employee is aware of everything that happens through the year involving injuries or accidents or injuries. The other use of this is data collection. This goes to NIOSH, which then compiles all that information and makes those pretty charts that we saw in the first lecture, and also lets OSHA know what the status is, what relative risks are, what things they should be looking out for, what things that are going on now that aren't being addressed. So, now, OSHA does have an enforcement capability. They have people who work out in the field. For example, in New Mexico, the field agents spend about half their time going to agricultural sites, and most of the rest of their time going to construction sites, because those are the two places in their jurisdiction that they have the most concerns. So when they're going and doing this visit, if they see something that is really bad, let's say a set of scaffolding that looks shaky, they can go to the employer or the supervisor and say, I think you should stop your operation because of. And the amazing thing is this works a lot of the time, because these operations are very, very complicated. There's lots of things going on. The people running them have lots of things on their mind, and sometimes they just overlook something. So this guy comes up and says, you know, that scaffolding is really scary there. You ought to fix it before sending anyone up. And the guy says, oh my God, yeah. And it takes care of it. So I'd say, last I talked to these guys, at least 90% of the time, they just say, hey, stop doing it. And they do it. Then if that doesn't work, they'll go to the employees and say, look, that scaffolding is unsafe. They actually advise the employees of the danger so they know about it. And then if that doesn't work, they can request a court order to halt the operation. And that may also be why this works a lot, because the company doesn't want a court order against them. But if they simply won't halt, these agents can get a court order and force them to stop. Now, if it gets to this point, we usually end up with a serious violation, in which case the field agent can assess a fine, which might be adjusted later, and file an advisement basically letting OSHA know what this person did and what the problem is. Okay. Now, if it's a non-serious violation, okay, let's say that the guy has the scaffolding up but hasn't actually had any workers go up there yet. It's still a violation, but no employees were put at risk. So there could be a fine. More often what happens is education. The field agent may say, you know, you really ought to check out this website, and the employee can look there and it'll give the employee very precise information on how to do things. And then there's the de minimis, which is the lowest level, and this is where the employer simply gets educated. Because a lot of unsafe things happen because people just don't know that they're unsafe. Believe it or not. Okay? Now, OSHA has had its problems. In some administrations, there's a lot of pressure. There's been pressure to exempt plants with few accidents. Well, they're not too unhappy about that. There's been a lot of pressure to reduce fines. That is something OSHA is not happy about, because if the fines are too small, companies won't change their behavior. And there has also been pressure to reduce regulation on some industries, another thing OSHA is not too happy about. Congress has put pressure on them. Some of the really bad things they did at the beginning led to a very poor public image. It was a few years ago, a guy got trapped in a trench that collapsed in El Paso, and two of his co-workers rushed in to save him, and that made the papers. And then federal OSHA, which works in Texas, fined the two rescuers for going into the trench without proper safety equipment. That made the papers too. And OSHA did not look good after that. So these kinds of things give them a poor image, and then of course Congress responds to public images, and they say, well, we need to cut this kind of behavior back. And there's been some policy gaps. In the early days, OSHA decided what they would do is they would just basically crucify companies that had done things wrong, because their philosophy was they would scare all the other companies into compliance, and that really hurt them badly, and it didn't really do any good, because what they found out after years of studying the problem, that the biggest problem is ignorance. People simply don't know, which is why now they've shifted to education to address the problems. So the standards now are accessible. They're based on the state of the art. Lots of people put input into these things. They're very comprehensive, but they are daunting. There's lots out there. In addition to all of this stuff, we have what's called interpretations. The laws are passed, the regulations are passed, the field agents make their decisions, the courts make their decisions, and that's really determines the level at which things are done, because if nothing else, OSHA tries to be even-handed with everybody. So the interpretations are important, and they also do consulting, because again, they want to take care of the issue, and education's a problem. Now here's, I clicked under interpretation. You go to the OSHA website, you click on enforcement, and then over on the right in a box they have letters of interpretation. And what each of these are, like I'll read this, it's too small to see on the screen. Removal of contaminated needles prior to disposal. And here are the sections that are relevant. And in addition, this is basically a finding either by the court or by an administrator in OSHA. And once this is done, this becomes basically the level. Clarification of HAZCOM provision intended to preempt conflicting state regulatory actions, but not tort claims. This really is specific. Clarification of utility owner-operator obligation to provide voltage information. So all those rules that we have there, they're a good guideline, but you really don't know where OSHA stands until you read these letters of interpretation. So this has been a massive project since 1970, and what good has it done? Well, the workplace death rate has dropped to half of what it was in 1970. Now the critics will say, well, that's due to better technology, but the OSHA people think they had something to do with that. It virtually eliminated brown lung disease, which was a problem at the time. Trench cave-in deaths are down 35%, and this is mainly due to requirements for shoring and for gear and for safety people. Overall injury and illness rates have declined in those areas where OSHA has been involved or they've focused on. It's remained unchanged or actually increased in other areas. And this is probably the strongest argument that OSHA is having an effect. And OSHA helped in the Katrina recovery, such as it was. The partnership program, OSHA will get together with industries or groups of industries to try to come up with a joint program that will improve safety. One is getting results and improving performance, GRIP. This came from Atlanta East Area OSHA office, Argonaut Insurance Company, and Georgia Tech Consultation Program. They got together with Horizon Steel Erectors. And the four of them together formed a partnership for the purpose of improving safety. They went to a 100% fall protection program, and they had a 96% reduction in accident costs in terms of worker hours. That, everybody wins when that happens. States can administer OSHA. Section 18 of OSHA Act 1970 encourages states to develop and operate their own programs. I think at the beginning they thought that was going to happen. OSHA approves and monitors the state plans. It must be at least as effective as the federal plan. Up to 50% of the funds to operate the state plans come from the federal program. So that's a good deal. And I have a map here of states with approved plans. And I was looking for an updated map, and it's this map is approximately correct. New Mexico has its own plan, as does Arizona. Texas does not. Federal OSHA, federal government monitors OSHA directly in Texas, but New Mexico monitors it in New Mexico. And this actually works out quite well for New Mexico because we have a large number of agricultural operations in New Mexico, and this is something that other states don't have. And the feeling was that the federal program just wouldn't be sufficiently attuned to what we do in this state. In Connecticut, Illinois, New Jersey, New York, and the Virgin Islands, they have OSHA, but it only affects public employees, in other words, state employees. It doesn't affect private employees. So private employees in that state, private operations, are still managed under the federal program. So you can see here, there's, as you look at this, it's not consistent. It's not quite as bad as workers' comp, but there's still a lack of consistency. At least, though, all of these programs meet the same minimal standards that are established by the federal government. And we have now in OSHA, and we saw also with workers' comp, this same mechanism. We have this body that generates legislation, and we come up with law and regulations that affects workplace safety. The driving force is public opinion. The Triangle Shirtwaist Fire drove public opinion to lead to workers' compensation laws, something we didn't have before. The things like the tunnel disaster caused situations the public were not happy with, and that drove the legislation that led to OSHA. But over time, OSHA's fortunes have waxed and waned depending on how strong this public opinion is and how strong this group over here is, and that will probably continue forever. Okay? All right. Any questions? All right, so what I want to do here, my computer won't talk to the interweb, so I'm going to fire up this other guy, and we can whoops. What the heck happened? We may get to the website because, frankly, you couldn't see anything on those slides. And I do want to show you what's going on then. But this computer now is giving me a hard time. It's configuring. Looks like it was in the middle of an update. So while we're here, has anyone had any personal experience with OSHA? No? Work?
At work, I had to take some OSHA courses.
Huh? Took some.
4 hour and 40 hour.
Now, were they courses from OSHA or courses about OSHA?
There were courses about OSHA to get certification.
Oh, did you learn anything?
Yeah.
Interesting?
It was interesting. A lot on chemicals.
A lot of what?
A lot of stuff on chemicals.
Chemicals, yeah, I didn't go into that, but that is a biggie. Let's see if this works now. What's that?
I didn't have to pay for it.
You didn't have to pay for it. Now, that's the kind of course you like, right?
Right.
Was it in Hawaii?
I wish.
Oh, not in Hawaii, okay.
No, it wasn't like that. It was online. And El Paso.
El Paso. Well, El Paso, Hawaii, sunny places.
I saw palm trees on the way home.
Palm trees, yeah. Got palm trees. Where did I go? Went someplace that was really surprising. But they had palm trees there. What? It was up north somewhere. How did that happen? Well, here we go. We have something. Let's see if we can fire this up. Okay. Okay, so here we are. All right. Someone gave me a search term here. What do you want to look about in OSHA? Any ideas?
Trench depth.
What is it?
Trench depth.
French dip?
Trench.
Trench digging. Ah.
Trench digging. Trench depth. You know, what do you do? I know. You guys
Okay. I thought you said French dip. I say, well, they might have it in there. Okay, let's see if I can get this up to where people can actually read it. Okay, so can we read that? Results, 1 to 10 of about 9,580. Okay, trenching and excavation safety, specific trenching requirements as it pertains to something. Trenches less than 5 feet in depth should also be effectively protected with when examining of the ground. Bad English, right? OSHA Technical Manual, Section 5, Chapter 2, Excavations, stacking trench boxes in trenches, permissibility of using average excavation depth, timber shoring, we'll talk about that later, clarification concerning fall protection in a trench, removing ladders during trenching, fatal facts, accident report number 52, excavations, occupational safety and health administration. It's from all over. Okay? Now let's go back here. Here we go. Protecting salon workers from formaldehyde exposures from hair smoothing products. So OSHA goes into all businesses, not just factories. Here we go. Picture it, safe workplaces for everyone. I guess they're working on a beach. The flu. They cover lots of stuff. There's our trenches. That's the one on the other one. Latest news, new short videos from OSHA provide training. You can't read that. Let me blow it up a little bit. Can you read that? Probably not. All of these sites are busier now than they used to be. Here we go. New short videos from OSHA provide training to help inform workers on the proper use of respirators. So these are videos now that an employer can download and use in their training program instead of paying someone $5,000 to come in and do it. OSHA and the American Pipeline Contract Association renew alliance to protect safety, health of workers in the pipeline industry. That's one of those partnership things. U.S. Labor Department files complaint to require DeMoss supermarkets to address hazards at market basket stores in Massachusetts and New Hampshire. So they're playing hardball with that company. OSHA orders AirTram Airways to reinstigate pilot, pay more than $1 million in back wages and damages. That's probably from a whistleblower, someone who made a report and signed the report and was subsequently fired. So go to the site, play around with it if you're bored and the TV isn't working or something, and see what's there. There's really a lot of stuff. Most importantly, if you do have a safety issue, this is a great place to start. Okay, so back here. Whoops. I got some links here. Triangle shirtwaist, tunnel disaster, OSHA Form 300. This link here, if you go here, they now have this nice little packet. It's about 8 or 10 pages. It has everything in there. The form, the instructions, yada, yada, yada. There's also an Excel version of the form, which a lot of people like to use. There's the NAIC, North American Industrial Codes. Okay. Next time, we're going to talk about basic hazard management, and that's supposed to be structures. Whew, where'd that come from? Structures. And you can read about this in Chapter 9 of the text in sections 10.1 through 10.4. Any last questions? Okay, I guess we're done.